certain evaluations done in custody. I see that you were placed on probation in May. So why did you not follow through with those evaluations out of custody?
I was only on probation 8 hours.
I'm sorry?
8 hours.
Yes. So what happened?
Okay,
So you 8 hours and then this incident is alleged to have occurred?
To maybe shortcut, Judge, he went home. There were some people living in his home that he was trying to get out of his home. An altercation happened. It was people that were trying to get him to use drugs, Judge. And he was trying to do the right thing. He told me this story and told several people that story, but he was trying to fix the problem so he could be successful. And here we are. And he's been in custody since.
2025 CR 003649, State versus David Wayne Huff. Can I have parties announce?
Matthew Finch for David Huff, Your Honor, ready.
And are you Mr. Huff?
yes, ma'am.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram, within 1,000 feet of a playground, and that makes it a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. They will take in consideration 2025 PF 06925. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plea?
No contest.
State any evidence.
State offers exhibit 1 and attachments, Judge.
We've reviewed those, Your Honor. We have no objections.
Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty and the court will find you guilty.
Here it is, the turning point. Judge Boyd reviews the evidence and delivers a guilty verdict. This isn't just a slap on the wrist. Possession of a controlled substance within 1,000 feet of a playground elevates the charge to a third-degree felony. That's a big deal. We're talking a punishment range of 2 to 10 years in prison. And yet, instead of prison time, the court is considering community supervision a massive opportunity for Huff to turn things around. The stakes just hit the ceiling, and now it's all about whether he can live up to that second chance. Asterisk.
All right. Positive for what? And what else? All right. So here's the thing where
This is where it gets personal. Huff shares that his drug use began after the traumatic loss of his father, a tragic moment that derailed his life for over a decade. But trauma alone doesn't excuse action in Judge Boyd's courtroom. You can hear her testing his resolve. Do you have a support system? Do you have stable housing? A job? She's not just sentencing, she's probing whether he's truly ready to break the cycle. Let's be real. How often do we see people at rock bottom who say they're ready, but aren't? Let us know. Do you believe Huff is serious about getting clean?
Are you working at all?
Yes, sir.
What do you do?
I work right now. I work for People Ready.
I'm sorry, what?
For People Ready as an electrician.
Okay.
So,
All right. This is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with Veronica Renee, Renee Trevino. There's to be proof of employment within 30 days. No employment as a home health care provider or with.
Judge Boyd doesn't just hand down probation, she engineers it. No contact with a specific individual. Strict employment limits 200 hours of community service. 120 sober meetings. Felony drug court, TAP evaluation, The list goes on. This isn't just supervision, it's structure with a warning label. And if he misses even one appointment, she makes it crystal clear: revocation is coming. This is where a lot of people slip, not in court, but out there in the daily grind. Would you be able to keep up with these requirements if your life depended on it?
Recommendations. Probation, is there anything else he needs? And I'm sorry, taking consideration 2025 PF 06925.
Judge, may I approach?
Yes. Is there anything else you need from the court in order to be successful?
No, ma'am, I appreciate it.
In this court, to be successful on probation, communication is key. So if there's an issue, talk to your probation officer. If you feel as though they're not addressing it, you can always come back to court. And nobody can help you, and we can't help you with your drug addiction if you don't want to help yourself. Now, I've ordered that you have a TAP evaluation out of custody. They're going to give you a date for that. If you miss that date, what's going to end up happening is a motion to revoke is going to be filed. You're going to be taken into custody. Either you'll make bond or you won't make bond, and I'll hear that motion to revoke.
This is where the court lays it all on the table. Judge Boyd hands out a probation sentence, but this isn't a free pass. She builds a wall of conditions: no contact with specific individuals, no employment near minors, drug court referral, 200 hours of community service, and 120 sober meetings in 120 days. That's not just strict, it's relentless structure. The judge even warns him that if he misses a single evaluation, he's looking at full revocation and possible prison time. This isn't a suggestion, it's a clear roadmap. Succeed or self-destruct.
No, Your Honor, we're going to plead true with an agreement to continue on probation, with the evaluations to be done in custody.
And is this a misdemeanor assault?
It is a non-family misdemeanor assault, Your Honor. And there's already an agreement in place. I'm not the lawyer on that case, but there's an agreement to dispose of that case.
And what's the agreement on that case?
90 days to do. He will have probably racked up enough time by the time he's in custody, getting done his obligations.
All right, so you understand, if you have an agreement with the state of defense, I don't have to follow that agreement. Do you understand that? All right. Court is calling 2025 CR 003649, State versus David Wayne Huff.
This right here is Judge Boyd's warning shot. The defendant misses even one date, one evaluation, a motion to revoke gets filed. He's going straight back into custody. The system doesn't play games when you're given probation. With this many lifelines, the court even tells him how to stay organized. Get an appointment booklet. Write everything down. Treat this like survival, because it is, he's told point blank. Either you get clean or we identify your body. That's not fear-mongering. That's reality. The judge has clearly seen what happens when defendants ignore structure. This is her moment to put the entire weight of the law and her experience behind a single message.
Years. All right, State.
Violation of condition number 1. On or about the 16th day of May, 2025 in Bexar County, Texas, the defendant, David Wayne Huff, committed the offense of assault in violation of condition number 1.
All right, and how do you plead?
Sure.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to continue probationer on probation, but to allow for all the evaluations that have not yet been complete to be completed while in custody. The state understands.
Here's the moment that shocks the entire room. The judge asks, "Why didn't you follow through?" And Huff replies, "I was only on probation for 8 hours. That's not a figure of speech, that's literal." 8 hours before. An assault landed him right back in custody. And what's wild is his defense. He says he was trying to get people out of his home who were pulling him back into addiction. This one's murky. You've got someone trying to clean up their life, but chaos hits first. Drop your thoughts below. Is this bad luck or bad judgment?
Huff,
All right, so Mr. Huff, they're saying that they want certain evaluations done in custody. I see that you were placed on probation in May. So why did you not follow through with those evaluations out of custody?
I was only on probation 8 hours.
I'm sorry?
8 hours.
Yes, so what happened?
Okay, so
So you 8 hours and then this incident is alleged to have occurred?
To maybe shortcut, Judge, he went home. There were some people living in his home that he was trying to get out of his home. An altercation happened. It was people that were trying to get him to use drugs, Judge. And he was trying to do the right thing. He told me this story and told several people that story, but he was trying to fix the problem so he could be successful. And here we are. And he's been in custody since.
This is where Judge Boyd shows why she's respected. She listens. After learning the full story, she still gives Huff a chance. Instead of revoking his probation entirely, she modifies it. Evaluations will now happen in custody and all prior. Conditions stay in place. It's firm, but not merciless. She's basically saying, you've got one more shot, and this time we're watching you closely. But let's be honest, how many people get a second chance? Think Judge Boyd made the right call here. Or should she have revoked probation outright?
I think somebody's already ordered you to have 120 sober meetings in 120 days. Was that previously ordered?
It was, Judge.
All right. So you're to make sure that you do that. If for some reason, because the systems are down, if some reason they release you from the Bexar County Jail, you know you're not supposed to be released, right?
yes, ma'am.
If for some reason they release you, don't fight them over it. Just come back to this court in the morning, okay?
Yes, ma'am.
All right. Do you have any questions about anything?
No, ma'am, thank you.
All right. Is there anything else you need from the court?
No, ma'am, I'll be successful.
All right. If in this court to be successful on probation, communication is key, right?
Yes, ma'am.
So if you need something, let probation know. If they feel like they're not addressing it, you can always come back to the court.
Yeah.
But whatever you do, don't do this thing where you don't
And that's where we leave it. David Wayne Huff walked in hoping for leniency and walked out with one final chance. Under the watchful eye of Judge Boyd and an entire courtroom that's seen stories like his before. From a felony drug charge, near a playground to an assault just 8 hours into probation, his story is a cautionary tale about how fragile redemption can be. The judge has made it clear, slip again and there may be no next time. If you found this case as shocking, as we did, hit that like button, drop your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.